Thank you.
The Honourable Jerry Brownlee.
Thank you, Mr. Chairman. Can I first acknowledge David Parker and thank him for bringing that matter to our attention. There are some who would say it is probably more belts and braces than anything else. I personally think you found a problem that could have occurred, and so it's appropriate that it is fixed, and I acknowledge the vigilance of the member in finding that. I'm not in their caucus, so I don't know those words, but can I just answer the questions raised by Jan Logie? Firstly, in Christchurch, we had the SARA Act, and the SARA Act gave not only the Minister but also the Chief Executive of SARA very extensive powers inside a defined geographical area. So you also had a very large number of very obviously dangerous buildings, and that's why the CBD was put into a cordon as a whole, and then gradually that cordon was let out as buildings were demolished or remediated. And the point here is that you also have the Building Act, which makes it very clear what happens in the event of a dangerous building being evidently so. The gap we're trying to fill here is perhaps there may not be an outward physical manifestation of something that does make it dangerous. So we're trying to ensure that there's a way of finding that out in this particular bill. And I think it's not unreasonable to put people in that, and it would give people that level of comfort. The other point was, I think Clayton Mitchell raised the issue about the absent landlord and therefore defying. Well, there should be an address for service in New Zealand for every building, and that presumably would be the agent who has some authority in this case. They would certainly have an ability to receive the demand. Now, defiance could well lead to the council also reverting to the Building Act and slapping a 124 notice on the building, in which case every tenant would be notified that it cannot be entered. What we're trying to do is put a halfway house, and you spoke also about the overly zealous person who gets the clipboard, etc. You could either take care of that latter problem, in which case you would be a little more lenient on the person who might be in the defying position. So we are really trying to get a bit of a middle ground here. But once again, if that building was, if they just said, well, no, we're not doing it, and the council believed that there was a problem, and they would only be asking, remember, under the terms of this bill, if they believed there's a problem, then they could put that 124 notice on, all tenants would be notified and automatically evacuated. And the cash flow on the building ceases at that point. So there's quite a bit of incentive on landlords to play ball. And I want to say again, I think landlords will. It's just where you get the one or two that might not be willing to face the reality of what they're dealing with. I think the gentleman who is the owner of 61 Molesworth Street has set the pace by being very, very cooperative with the council, absent of all this provision, simply because he could see that there was a greater need, and presumably had arrangements with his insurers that recognise that as well. The other point was, well, post-inspection, what if the inspection is done on a Friday or is completed, because it'll be a long assessment, several days, on a Friday, and the tenants aren't notified until the Monday? Well, if it was found to be on the Friday afternoon in a bad state, once again, it would be red stickered and evacuated. So those are provisions that exist in current law. Just remember, this little bit that we're putting in here fixes a little gap in the whole thing. And I think it goes far enough to prevent the overzealous approach, but to make it very clear that there is a high level of expectation that those who have big buildings where human life could be at stake if there was some sort of catastrophic event should play ball. Mr. Speaker, Mr. Chairman, there was also a question raised about the tenants' rights to receive the information. Mr. Chairman,
Honourable Jerry
I won't be much longer. I think it would be interesting to know what provisions are in each lease deed on any building, but I would expect that there will be responsibilities outlined in that lease around the maintenance and care of that building, and a delineation between what a tenant will do in that building and what the expectations of the landlord will be. In any event, there's the wraparound of the Health and Safety Act, which means that if you own a building, and you may be a body corporate doing this, which I think will challenge a lot of body corporates throughout the country on this, and we may even discover, as we did in Christchurch, that many buildings should have had body corporates that didn't. And I hope that that will get remedied in a relatively short period of time. But what you then have is the duty of care to all those who are occupants of that building, excuse me, under the Health and Safety Act. So, repeating again that we've got a lot of acts that sort of go around the edges of this. What this tries to do is pull it all in so that there's that strong expectation, that strong requirement, that legal requirement that if you're asked to deliver something, you have to. Now we have this SOP coming in from David Parker. It means that once you're asked, you've got to comply. You can go off and appeal if you like and look at your costs, and you might be awarded costs because it may have been unreasonable, but you must comply, and that's must comply. And I think that's the strength of where we've got to today.
Members, so the question is, sorry, Ron.